For the next 30 minutes, you have a chance to call the law. Keith Williams and Don Higley are here to answer your criminal and civil law questions. Call now, 561-TALK. That's 561-8255.
Pleased to present criminal attorney Keith Williams and his co-host civil attorney Don Higley. They are here every Tuesday night from 6:30 to 7, live on the radio at 103.7 The Source for talk, news, and information, and live on your television on Greenville's Cable Channel 7. This is your chance to talk to a lawyer for free, to learn everything you always wanted to know about the law, but were afraid to ask. I invite you to call us and join the conversation now at 252-561-TALK. That's 561-8255. Join the conversation now as I turn it over to our hosts, Keith Williams and Don Higley.
Good evening, Don. Great to be back with you again tonight.
Yeah, a couple live shows in a row. We're on a roll.
What are we going to do? Tuesday, May 1st, 2012. We invite you to give us a call tonight. If you have questions about the criminal law for me, questions about the civil law for Don, our number tonight is 561-8255, 561-TALK. We're here to answer your questions about the law. Don, it's been a busy week since we saw each other last.
Yeah, I've certainly been busy.
You and I have been working on a little case together. We had some overlap, got that case done. Now we're looking ahead.
We got that finished, settled. It was a good thing for everybody.
I got a trial calendar. I'm out of county. I got a trial coming up the week of May 14th, and I'm number 33.
Yeah, and you'll get reached.
Which means definitely I'll be reached. That's right. I talked to one of the other attorneys involved.
32 chickens in front of you.
That's right. And he said, I got case number 1. It's going to take all week, and that's the kiss of death, man.
Yeah, right. I'm sure.
You know you're going to be reached if that happens. 561-8255, 561-TALK. If you have questions about the criminal law for me or questions about the civil law for Don, we invite you to give us a call at 561-8255. Don, not only going to be a busy week, a busy couple of weeks in terms of court and legal stuff, but also got a continuing legal education seminar coming up here in Greenville.
Right. I actually saw that advertised. I'm a member of the Advocates for Justice that you're putting that on under their umbrella, and I saw that and brought it in one day and plugged you by surprise.
North Carolina Advocates for Justice, that's right, here in Greenville, North Carolina, hosting a seminar on defending drug cases on May 11th, going to be held over at the Hilton. And it's a fairly big deal when the Academy comes to town, or I should say the Advocates for Justice come to town, because they do statewide CLEs all over.
Yeah, right, and they'll actually film it and play it, and people can be in Asheville and watch it over the internet, which is kind of cool.
That's right. Yeah, we've got folks, at least 10 right now, signed up online. Have 30 to 40 who have signed up to come in person, so it should be a good day for Greenville.
That's a really good turnout. It's a little intimidating, though. The last one I did was up in Greensboro, and I had an easel there and had prepared remarks and an outline, and I went up to get in front of the camera and set it up there, and the thing flopped over and made a big noise, and kind of embarrassed myself in front of the entire state.
561-8255, 561-TALK. Questions about the criminal law for me or questions about the civil law for Don, 561-8255. They didn't have the audio-visual stuff? You didn't take your computer up there?
I'm not Mr. What do they call that my kids can do?
Mr. Technological?
No, the presentation software that everybody uses.
Oh, Mr. PowerPoint.
Yeah, PowerPoint. That's right. I can't even call the name.
Well, you're getting better at it, though. A lot of courtrooms now are really going to that way.
Yeah, and I've used it in trial, and I just get the paralegal to come and deal with it for me.
Especially in federal court around here. Most of our federal courts have a pretty good audio-visual presentation system, and the judges make pretty clear that they want everybody to use that.
Right. And it's obviously a lot faster, and I tried one up in federal court, and we did use it, and it's certainly not difficult to manage, and it's a lot easier if you're popping up a document instead of approaching with a blow up and having a witness come down in front of the jury box. Just pop it all up on a monitor, and everybody can see it. Judge has a monitor; he can see it. Mm-hmm. Witness can see it. You don't have to move from counsel table. Kind of cool.
Mm-hmm. Yeah, that's right. I've got a new application for my iPad called TrialPad. You load everything in as a PDF, and you hook your iPad up to the projector, and you can make it big or small, or mark it up with your fingers. All kinds of neat stuff.
Wow! Does that app cost money?
Costs $90, but I think it'll be worth it.
Yeah, definitely. I need to get an iPad because I love my iPhone. We really shouldn't advertise for people without getting paid, but it's amazing. I was thinking the other day. I don't know what in the world I did when I first came out. I remember the senior partner at the firm I started out with had this big old bag phone in his car, and I thought that was so impressive that he could pick up a big old bag phone and talk on it while he's in his big old car.
Back in the day, that's right. 561-TALK, 561-8255. If you have questions about the law tonight, questions about the civil law for Don, or questions about the criminal law for me, we invite you to give us a call at 561-8255. We've got some open lines, so give us a call in tonight. If we could maybe close that door there, that'd be great. Appreciate that. 561-8255. Don, a lot of news here lately about the United States Supreme Court, and especially about someone known as the Solicitor General for the Obama administration.
Right, yeah. We were talking off the air about news, and both you and I have been sort of short on the news lately because we've been so busy. I come home and I see my paper lying in the front yard. No one's even gotten it. But I've heard he hasn't done a spectacular job, technically.
Yeah, it's come in for a lot of criticism. I thought we'd talk just a little about who that is. The Solicitor General is the person who argues on behalf of the United States, or essentially on behalf of the President at the Supreme Court. And it's generally a very well-respected position, an attorney with a lot of experience who is up there. And without commenting on the merits of the cases, the Solicitor General apparently this past week had some trouble in that immigration case out of Arizona.
Right, and it also completely botched the arguments in the health care legislation.
Yeah, that's right. That's right. Now, conservatives, not that I'm one of them, might say that he had an impossible task to defend an unconstitutional law and to try to explain how it was constitutional. But even putting that to one side, as I listened to the transcript, it seemed like he was real nervous.
Yeah, it appeared that, well, from the commentary, I actually didn't either review the transcript or see any video, of course, since they don't have it. But I heard that he just got nervous and froze up, that it wasn't a matter of just botching his argument or not being able to defend it. He just choked.
Right, right. And he had to go for the water pretty early, and it excused me, and it interrupted him.
Yeah.
I never want to go for the water when I'm speaking because I'm always worried my hand's going to be shaking a little bit.
Yeah,
and they're going
right.
to see me when I go up to drink it there.
I know that I've been, at the Court of Appeals and the Supreme Court a few times over the years, and there's never been any water anywhere near me. I'm too busy concentrating on what I'm talking about to even think about a drink of water.
And you see that picture there sometimes, and I think to myself, no, if I pour that, I am for sure going to spill it.
I've done that in trials where the deputy likes to set a bunch of ice in there. And
Yeah.
you do the old ice avalanche thing, and the jury looks at you like, that clod can't even pour himself a drink of water, and we're supposed to believe him.
What a dork. You go to the seminars, and especially some of the national seminars, and they have some of the big-time attorneys on to speak. And it's been interesting to hear those guys. They say if you ever get to the point where you're not nervous at all going into trial, you need to go do something else.
Yeah, right. And they definitely, you do have to think about little things like that. I remember one of the senior partners early on telling me, don't be drinking water. The jury doesn't have it. So you need to stay away from it, and all you're going to do is knock it over and get your papers wet anyway. And little things like that do kind of add up. If you're kind of a clod throughout the whole trial, it's tough to sort of gain their trust, and they don't know why they're trusting you, but it's because you're smoother than the other guy, and you seem to be under control. And some of the most horrible things have happened in court. And another mentor of mine told me, whatever it is, just act like it's exactly what you thought was going to happen.
That's good advice.
Move on.
That's good advice. 561-8255. We've got Joe holding on the line. Joe, welcome to Call the Law. Hey, Joe. Joe, we've got you on the line. We're hearing a little feedback there. If you could turn down your radio, we'd be glad to talk to you tonight. How are you doing?
Doing good, sir. How are you?
Doing
Good,
fine.
that's better.
Good. You remember back in February when those twin brothers attempted to rob the restaurant there in Williamston?
Don't specifically remember it, but a lot of cases like that going around. Yeah, so you had a question about that
Okay.
case?
Well, anyway, I was just wondering, I believe one had a knife, one had a screwdriver. I know the knife would be considered a deadly weapon. Was the screwdriver also? Because I believe one is going to district court and one was carried over to the Superior Court. Can you enlighten me on that?
Sure. The one that stayed in district court, do you know if he was a juvenile? Was he somebody who was under 16?
Oh, no.
So he was over 16.
Oh, yeah.
In one
34
case,
years old.
Right. One case stayed in district court, which, as you know, but just for the benefit of our listeners, is generally a court that handles misdemeanors, where Superior Court is generally a court that handles felonies. And so in a situation like that, the person who had the knife could be charged with armed robbery or assault with a deadly weapon with intent to kill, depending on the exact facts of the case. But the person with the screwdriver apparently had their case stay behind in district court. I'll tell you, I'd be interested to look at the case files, because it may be that they got to the knife guy first and that they're coming around to the guy with the screwdriver but haven't gotten to it yet. If you and I go into a store, you have a gun and I don't, but we're both there to commit a robbery together, then we're both guilty of the armed robbery, either because I aided you, or I was in conspiracy with you, or we were acting in concert together. So I would be surprised, unless there are some other facts, if the guy with the screwdriver was left behind in misdemeanor court while only the guy with the knife went forward to superior court. And if that happened, I would guess that it's probably just a paperwork thing, and probably the other guy's case is going to be going up to superior court in due course.
Okay, well, maybe I misunderstood the facts, but an armed robbery with a deadly weapon, that would give someone about, what, maybe 12 to 15 years in prison?
Well, it depends. Robbery with a dangerous weapon is the technical term in state court. We all refer to it as armed robbery. If the person has a serious record, then yes, they can get long sentence in prison. If they've got no record at all, they're still going to be looking at a prison sentence, normally speaking. I don't know if it would be 12 to 15 years. I would suspect it'd be something less, and I don't have the punishment chart in front of me. But just off the top of my head, in state court, I think for a first offender on an armed robbery conviction, it would be less than 12 to 15 years. Now, in federal court, if a person commits a robbery and they have a gun with them, that's a whole different deal. So if they go in and in the course of a crime of violence or any kind of drug trafficking crime, if they have a gun, it's an extra 5 years over and above whatever else they'd get. If they pull the gun out, it's called brandishing. That's another 7 years. If they pull the gun out and shoot it, that's discharging. That's an additional 10 years. So a person who's taken into federal court on a robbery case is probably looking at 5 to 6 on just the robbery part, and then with the gun can be looking at another 5 to 10 on top of that. So you're right, you can get to those levels, and it may be that you'd heard about a federal case, because those can get to those levels real easily.
Mm-hmm. Okay, well, I appreciate your information, sir.
Thanks, Joe.
Great. Joe, thank you for listening tonight.
How do you end up
Thank
in
you.
federal
Bye.
court?
5618255. How do you end up in federal court?
On a robbery.
You know, it's a great question, because most cases stay in state court, and yet federal jurisdiction is so broad that they could bring in a lot more than they do if they wanted to.
Interesting.
On a robbery case, it's typically what they call the Hobbs Act, which is where you commit a robbery at a business in such a way that it interferes with interstate commerce.
Okay.
And as you remember from your law school days,
Very
interstate
broad.
commerce is extremely broad. So if I rob the Burger King, well, Burger King has interstate locations. They're all throughout the country.
Right.
And technically, I've trampled on, interfered with interstate commerce.
Right. And they, I guess if it's somebody that they've really been after for federal reasons, they might just prosecute the gun crime in order to get them on other stuff, potentially.
Yeah, that's right. That's exactly right. And or if you have a rash of armed robberies, I think I read in the paper here recently that the federal authorities here in Pitt County took some of the armed robbery cases over to federal court on a Hobbs Act theory.
Okay.
And that's the same kind of thing. When it kind of gets to be a rash, comes to their attention.
Wouldn't want to be the lucky guy who drew federal court when
telling
you
you.
went in with a screwdriver and a knife to the restaurant in Williamston.
All my other buddies got a state sentence, and I'm going to federal court.
Yeah, not good.
5618255, 561-TALK. Questions about the criminal law for me, or questions about the civil law for Don. 561-8255. Don, I know you're spending a lot of your time doing personal injury cases these days.
Yeah, I sure am, although I've been working my tail off on a non-personal injury case this week. In fact, I woke up and it was like 6:15. I'm at the office. I'm saying, uh-oh, better get over to the studio pretty quick.
Now, you've had a lot of experience in civil practice in general, but in particular with the personal injury cases that you're handling now. We've talked about them in the range of automobile accident cases. We've also talked last week about some of the wrongful death cases that you do.
Right.
You cover the whole spectrum.
Oh, yeah, absolutely. Fortunately, at my age, usually when I'm dealing with a personal injury case, it's something very serious in terms of the injury that's occurred. But as far as the particular negligence or the person that ends up being responsible, it can be in a variety of different ways.
And is the central, if I recall back to law school, is it still that you have the central components, if you will, that the other person had a duty to look out for you?
That's right.
And they didn't, and you got hurt because of that?
That's right.
Hurt or killed?
That's right. Yep.
That's what they all come down to.
Breach, causation, damage.
So if you have somebody walking through a store, they slip and fall, Do they automatically have a case against the store because the store has a duty to keep them safe, or do you have to prove the store knew about the banana peel on the floor?
Yeah, no, you definitely, premises liability cases are very difficult because they're not insurers of your safety. They just have a duty not to negligently harm you. So if a banana peel gets dropped on the floor, or in a case of mine, a piece of hamburger in the dairy aisle, and they don't notice it for a period of time, they don't clean it up, they don't keep the store neat, and you can prove all that, then you've got a potential case. And even then, you oftentimes have issues of your own responsibility. Should you have seen it? And did you contribute even in a tiny way to your own injury?
Because I think sometimes people assume, well, they were at Walmart, they fell, they're going to make $1 million.
Yeah, I get those calls a lot. And when I explain to them, I ask them, what did Walmart do wrong? Well, nothing. I'm like, well, then you don't have a case.
Because Walmart is not there just to generally ensure that you're safe in their store.
That's right. It's not, obviously, it's not possible to prevent everyone from falling. So, things can fall on the floor, and if they have a reasonable way to deal with that in place and they react to it relatively quickly, then you're not going to be able to prove anything. I've never had a case against Walmart, and I've been doing it for 19 years.
Wow.
So,
Wow. All right, that's good to know. 561-8255, 561-TALK. We've got Tiffany holding on the line. Tiffany, welcome to Call the Law.
Hi. I have a question that has to do with an old child support case. My mom just passed away last November, and she recently started collecting on some arrears that were owed her, and she's still owed about, I don't know, maybe $192,000. And I was wondering if her estate can collect on that, or if the debt is just forgiven because she's passed away.
that is a huge arrears. Yeah, I bet Keith doesn't know the answer to this completely off the top of his head. Neither one of us have practiced in the area of domestic law in a long, long time. Certainly, I'll say a couple different things about it. Number one, the average debt where somebody owes you $192,000 doesn't go away simply because you pass away. It survives, and the administrator of the estate can pursue it just as the person could have had they lived. And you often have that situation, and you often do pursue debts after somebody passes away. The other thing I would say is that child support rules in general are certainly not any more lenient than the rules that apply to any other debt. So I'd be awfully surprised if you had somebody that just borrowed $192 from you, didn't pay you back, you pass away, and you still have a case. I'd be awfully surprised if there's a rearage award in child support and that gets extinguished when somebody passes away.
Right, it's probably something you can still collect on. How did it get to be $192,000?
Yeah, that is huge.
Well, there's 6 children, and he just never paid. And I think the only reason he started paying was because he was tracked down. And I found online that he was put in jail, actually, and for a couple days right around a couple months before he started paying. And so I think they must have caught up with him and, put him in jail and started like the state or something must have followed up on it, because my mom had just let it go, thought it was never going to happen, and then all of a sudden she started receiving monthly payments of $1,600.
Wow.
Yeah, that's tremendous. And, folks with child support questions or child support needs don't have to hire a lawyer. There is a Department of Social Services here in Pitt County that has a division that works on child support and will do that on a pro bono basis. And you mentioned people being put in jail. If you're under an order to pay child support, you go in front of the court and the court finds that you're willfully failing to pay that child support. I know, Don, I've seen people put in jail over that.
Yeah, well, as we've also talked about, if you don't have it, they might not put you in jail. But if they find that you have it and you're not paying, then you've got a big problem.
Exactly, that's right. Tiffany, I think we'd encourage you to talk with the attorney that's handling the estate, or if you don't have an attorney who's handling the estate, we would encourage you to contact the Child Support Enforcement Division at the DSS, the Department of Social Services in your area, to see if they can help you with that child support issue, because that's a huge amount. We'd certainly want to see the kids get what they have entitled to.
Well, all the children are adults now. The youngest is, my little sister's 27, and the oldest is 39. So.
And you're one of the 6?
Yeah, and I'm one of the 6. So we don't actually have someone. She didn't really have anything to divide, but from what I understand, one of us just needs to get appointed to handle the estate. But I just didn't know if you could actually collect that money since all of us were adults now.
I think that I don't think it matters that you become adults. I think once a person is under an order to pay back child support, then they have to pay that, even if the kids have aged out, because the theory is it's for when the kids were younger, even though the kids are older now. But I would encourage you and your brothers and sisters to get together and put the money together to have an estate attorney or to have a family law attorney look into this, because if there's 6 of you. If each person could just chip in like $500 or $600, you'd have enough money to sit down with a good lawyer, and that would be worth the money to go after $192,000.
Okay, gotcha. All right, thanks for the advice.
Okay, good luck, Tiffany.
561-8255, 561-TALK. Questions about the criminal law for me or questions about the civil law for Don, 561-8255. Don, as you mentioned, we don't practice domestic law. We do
Nor have we either one of us been divorced yet. So that's good, too.
Yeah. Oh, my goodness. You got some news for us there?
Yeah, I made it to 20, so I think maybe I'm on the downhill side now.
You're on the downhill side of a lot of things. But anyway, talking about child support, there's a schedule that's actually issued by the state where it's not just the judge chooses a number out of the air, but the judge takes the husband's income, takes the number of kids, and I'm assuming here the husband is paying, and says, all right, you have to pay this much money out of your income for these kids.
Right.
And once that's in order, that clicks by each month. So let's say it's $500 a month. You don't pay, it's back child support, or as Don put it, it's in arrears. And that will keep piling up, $500 a month, $500 a month, $500 a month. It will keep on piling up. You say, well, what if I lost my job? You better go back to court and get an order to modify what was entered earlier. Because until you do, that $500 a month is going to keep piling up.
Yeah, right. And it obviously becomes a bigger problem as it starts to pile up, just like any other debt.
Yeah, that's exactly right. But $192,000, the guy must have made a ton of money. Because even if you have 6 kids, if you only make $30,000 a year,
right,
there's only but so much you could pay.
Right. They're not going to, regardless of the volume of kids, they're not going to make you just pay all of your money to child support.
That's right. There's a limit. Now, child support is the one thing. We've talked about going to jail. You cannot generally be put into jail for failing to pay a debt. But child support you can, especially a willful failure to pay.
Right.
The other thing that you cannot normally experience in North Carolina is garnishment.
Right.
Except for child support.
Right, right.
So as you pointed out, the rules for child support collection, they're not only at least as good as everything else, but they're better.
Yeah, much better. And kind of like not paying your taxes.
That's right.
2 things you have to do, pay your taxes and pay your child support.
Are you current on your taxes, Don?
Yeah, oh yeah.
How about your child support?
I don't know about that. As I told them last night, they're not worthy of my child support because they don't do anything around the house.
Oh, man. 561-8255, 561-TALK. We've got Mark holding on the line. Mark, welcome to Call the Law. That's all right. I think Mark was
Lost Mark. He got scared about the child support and the taxes.
That's right.
Just mention that, it'll kill a show.
Coming up on the big platform, he couldn't handle it. That's right. Hey, I do want to take a second to thank everybody who listens and everybody who watches. I had somebody else, again, somebody new. So, I listen to you guys every week.
Yeah, it's kind of interesting. Get a call from Williamston tonight. It kind of reminds you there's so many people out there listening. I get those conversations all the time.
Yeah, our signal strength goes down to Kinston, goes over to Willow, Washington, up to Williamston, and as you and I at different times, we've driven even to Elizabeth City and have heard this station.
Right, exactly. I mean, it kind of fades out on my old car, but on my new car, I get it right through to Elizabeth City. It's kind of cool.
561-8255, 561-TALK. If you have questions about the criminal law for me or questions about the civil law for Don, we invite you to call us at 561-8255. Don, a lot of stuff in the news here lately here in Greenville about some criminal charges that involved the basketball players, 3 basketball players on the ECU's basketball team.
Right, 3 people who were not acting as rocket scientists at the time.
Yeah, sorry to hear that. And, we talk about that briefly. Those are pending charges, and as I understand it, at least just what I read in the newspaper, they are not convictions. So these young men have not been convicted of anything, and they're entitled to a presumption of innocence.
Right, and that's absolutely true of all 3.
At the same time, the school has an obligation and a responsibility to look into it, and whatever may happen or may not happen in the criminal court system, the school has a right to take internal administrative action.
Right, and they will suspend you, and they'll immediately announce it because they don't want the press finding out. As you know, you can just go downtown and figure out, or read the newspaper, and figure out who has been charged. So they want to file the preemptive strike. They won't talk about details about why they're doing it or how long. And then they let the system run its course and talk to the player. And obviously, if the player is innocent, they tell the coach that. The coach may reinstate him prior to his charge. I've seen that happen. But they may just wait, let the court system run its course, and then reinstate him.
That's right, and it's not that different from how normal ECU students are handled, and I mean by that non-athletic students, non-athletes. ECU has what they call an Office of Student Rights and Responsibilities, and if an ECU student is charged with a crime, it's fairly common for them to get a notice from the Office of Student Rights and Responsibilities saying, hey, you need to come sit down with us, talk to us about what happened, and talk about what we're going to do in this going forward.
Right.
And a lot of times, if it's a misdemeanor case, they're not going to be expelled from school, but depending on the nature of the charges, they may be placed on probation, they may be subject to certain conditions, they may have to go in for a substance abuse assessment, or otherwise meet some requirements.
Right. And they didn't affirmatively pick up on those things back when I was in school.
Yeah, the computers weren't as good when you and I were coming through. That's right. Now, one thing that gives the criminal defense lawyers heartburn is the fact that they're asking your client to come into a forum and talk about what happened.
Right.
And typically, when I have a client with pending criminal charges, the last thing I want to do is let them go anywhere to talk about what happened.
Right, because that person can end up a witness.
Exactly.
Telling the jury what the defendant told them about what happened.
That's exactly right. There's no privilege. There's no confidentiality. Now, the ECU folks would say, certainly we're not going to share it. We're bound by educational privacy laws, and that's true. But if they get a subpoena from the prosecutor,
right,
there's no privacy law that can be used by the defense lawyer to keep the ECU person off the stand.
Right.
A lot of times I have to talk with my students and say, look, you've gotten this notice from them. You've got to go in and see them. But the best thing to do is to say, I've got a lawyer. He said I can't talk about it, but whatever you want me to do, I'll do.
Right.
So you go ahead and make whatever findings you got to make. If you guys say I got to comply with some sanctions, that's fine. I'll cooperate with that. I just can't make any statements while I have this case pending.
Right. And and obviously it would be, you could, if it was something very minor, they might be able to talk about it, but in more serious things, you would definitely take the sanctions you get from the school over risking going to jail or being found guilty in the criminal aspect.
That's right. And if you completely bow up and just tell them that you're not going to talk to them and you're not going to do anything that they suggest or recommend or require of you, then they can go the next step. So you're trying to thread that needle between protecting the client's interests and yet making sure they can stay in school.
Yeah, sort of analogous to when we used to handle those insurance coverage cases together where you'd have a client get charged with a crime and I'm trying to preserve their coverage and their cooperation.
That's exactly right. That's right. Well, Don, we're coming up to the end of the show, and yeah, you're right. I'm glad they didn't have computers back in the day when you and I came through college because it was a lot of stuff flew under the radar
I'm
screen.
just going through that stuff.
All right, coming up to the end of the show, we appreciate everybody listening tonight. We want to turn it back over to our announcer extraordinaire to take us out, Mr. Michael Stewart.
Well, thanks, Keith and Don, and thanks to everyone, once again, in our TV and radio audience for watching and listening. If you need help with a criminal case, you can call Keith Williams at his office at 931-9362. If you need help with a civil case, especially a case involving personal injury, you can call Don Higley at 252-757-7777. And that brings us to the end of another great show here on Call the Law. We hope you have a great week, and we'll see you again right here next Tuesday night here on Call the Law.
Call the Law has been brought to you by Keith Williams from the law offices of Keith A. Williams online at williamslawonline.com and by Don Higley of the Lanier Law Group online at lanierlawgroup.com. And join us again next Tuesday night at 6:30 for Call the Law. lanierlawgroup.com. And join us again next Tuesday night at 6:30.
I hope you'll soon recover. Me, I go from one extreme to another. And then my friends just might